I don't know, but if it's helpful, the United Kingdom became a party to the Convention Against Torture in 1988, in October, I think it was, and so anything before that date would not have been covered by the rule in Article 15. It would have come on very late in her term. I suspect, I mean, I don't know what was there, but I doubt that there would have been a written policy one way or the other on this issue. The obligation in international law not to torture is a relatively recent obligation, at least in having a specific convention, and I think we're moving to a situation where probably even the drafters of the convention didn't fully envisage the types of scenarios that we are now discussing. I don't think it would have been at the forefront of their minds. I went through the whole negotiating history of the convention. This issue never came up, and that indicates to me that we're in a sort of new area, looking in the cracks of the convention to see where there is wiggle room.
Peter Bones. Chairman, forgive me, Professor. I mean, I don't think, unless you think otherwise, we're going to get very much further with this particular question. It's a hypothetical situation, and you'll really say you have to judge things on their facts.
I'll try.
Well, fine. But forgive me if you think you're covering ground that you've already covered. I mean, the example, which is one of a number that I think we probably want to put to you, is this: that if the UK intelligence services get information which they knew to have been obtained from what are described here as high-value detainees, and they knew they'd been subjected to torture, or to use the phraseology, enhanced interrogation techniques, would the receipt of that information constitute complicity?
If it was preceded by a conversation between the Prime Minister of this country and the President of the United States, that we will happily receive such information, go ahead and do it? Absolutely yes. Again, it turns on the factual specifics. It would be very surprising indeed, given the closeness of the relationship between Britain and the United States, for example, the authorities in Britain were not unaware of some change of practice in the United States. It is probably no coincidence that these issues happened and began to arise in June, July 2002. As Frank Rich wrote in a very excellent op-ed piece in the New York Times on Sunday, he drew the connections between all of this and the famous Downing Street memo. You know, we had very close relations between British and American intelligence services, a big meeting between them in July 2002. It would be very surprising if there had not been conversations around the kinds of issues that you're addressing. And if those conversations took place, then the content of those conversations could contribute to a situation in which the scenario you've just identified would amount to complicity.
Sure.
Well, two more hypothetical questions from me, Professor Sands. One is that if the UK intelligence services provide information and questions to foreign intelligence services or a country with a bad record, who they know to be torturing a detainee, would that provision of questions and information constitute complicity? And the second one is...
Can I just do with one at a time? Maybe a little easier. I need to be a little careful here, because that scenario is very close to another scenario that is sort of forbidden area for me as a result of Bar Council intervention. So I don't want to in any way indicate that what I'm saying addresses that matter at all. But my own personal view on the hypothetical situation that you give is that if the British intelligence services were to make questions available themselves or by written form under the door, in the knowledge that someone was being abused in violation of these international obligations, then I think it would be very strongly arguable that the issue of complicity would arise, because that would constitute, I think, a contribution to a process in which you are seeking to obtain a confession or information, which is one of the definitional elements for torture in Article 1 of the Convention. So that scenario, in a hypothetical sense, I think would raise the most serious issues.
And one step back from that, without knowing specifically about an individual detainee's conditions, if a country generally has a bad record of torture, like Uzbekistan, say, and questions are supplied.
I think it comes to this question of constructive knowledge. So if the individual is being held in a country where for many years torture has not been practiced, or under the control of a country where torture hasn't been practiced, I don't think you could be expected to assume, without further information, that there had been a change of policy which would bring you into the complicity situation. But on the other hand, if you were dealing with a situation where a country had a known track record of torture and abuse, and you were to participate in that way, I mean, if you look at the Committee Against Torture, it's a pretty low threshold of participation, driving someone to a place where they're going to be abused. And I think the link between driving someone, providing questions, providing information on the whereabouts is a very clear connection. So I think in that scenario also, there ought to be red lights flashing in relation to Article 4.
And the second scenario is that if the UK intelligence services sent interrogators to question a detainee who's known to have been tortured by their interrogators, would that constitute complicity?
Subject to the same caveat that I just made, and without wishing to express any view on any matter which I'm not allowed to express a view, I think that my personal opinion would be yes.
Thank you very much.
Leaving aside the case of Benyam Mohammed, what evidence is there in the public domain that any UK personnel were in fact aware of the changes in the US policy and practice?
There is material in the public domain. In a book that I had written before my most recent book, I looked at this issue and came across material which emerged, and I've not been involved in that case, so I'm free to talk about it, which concerned the court-martialling of Colonel Mendonca. And I think that it might be quite useful for this committee to look at the transcripts of the cross-examinations. I address that case in a couple of pages, which I can direct to the clerk of the committee, in my latest book, which caused me to receive a stonking email from a person not a million miles from the Ministry of Defence. But the evidence was pretty clear that we could trace what happened, and this, by now we're talking about September 2003. A visit is made to Baghdad and Abu Ghraib by US interrogators and lawyers on the 30th of August 2003. On the 14th of September 2003, the General Commanding Officer in Baghdad, General Sanchez, adopts a new regulation giving effect to these forbidden techniques: sleep deprivation, stress positions, hooding, nudity, dogs, so on and so forth, all the Guantanamo techniques, and they are used thereafter in Baghdad for a limited period of time. The facts surrounding the court-martial of Colonel Mendonca occurred on precisely those dates, 14th, 15th, 16th of September. And what emerged in the course of the hearing, but has never been teased out, was that it appeared that a British Army legal advisor had received information in relation to the legal advice and the change of policy in the United States. And that appears then to have migrated down to Basra, so you can track very directly the chain. Now,
do you know the name of that legal advisor?
I do, but I don't recall it. It's in. I mention it in the. I've set it out in the book with all the footnotes and all the witness statements which are publicly available and the transcripts.
I assume you know we've been looking at it from a different direction from what the Attorney General's advice was at the time.
Yeah. So we know that by September 2003, at least at the military level, there was a cross-fertilisation of knowledge of a change of practice. But what I've also managed to track is that the US position, of course, on the applicable standards changed much earlier than that. They changed in February, in fact on February the 7th, 2002. That was the crucial moment of change, because on February the 7th, 2002, the President of the United States adopted an executive decision which said that any detainee caught in the war on terror, anyone who was alleged Al-Qaeda, had no rights under the Geneva Conventions.